This episode of the Quantum Space Innovating Trust podcast is brought to you in association with Vibu Systems, pioneers in software protection, licensing, and long-term digital trust. Quantum computing is no longer theoretical, and it poses a fundamental challenge to today's cryptography. Methods like RSA and ECC will not survive the quantum era. With its next code meter generation, Vibu Systems is already preparing a smooth, compatible transition to post-quantum ready security across hardware, software, and cloud licensing. Discover how CodeMeter is being engineered for the post-quantum future and why preparing early is the only safe strategy. Visit vibu.com/PQC today.
The systems we rely on every day were never built to explain themselves. They were designed to function, to scale, and to deliver outcomes efficiently. For a long time, that was enough. Platforms connected people, infrastructure carried data, and algorithms made decisions without needing to justify how those decisions were reached. When something went wrong, responsibility was difficult to trace. It could be distributed across users, systems, and providers, which made accountability slow to establish and, in many cases, easy to avoid. That position is beginning to change. What we are now seeing, particularly through the courts, is a shift in how digital systems are being interpreted. They are no longer treated as neutral intermediaries. They are being examined as environments that have been deliberately designed, and therefore carry responsibility for how they behave. That distinction matters. It moves the focus away from user activity and towards system behavior. Design decisions, whether in recommendation engines, interface structures, or underlying logic, are starting to be viewed through the lens of liability rather than innovation. Once that threshold is crossed, the expectations placed on these systems change with it. It is no longer enough for a system to operate as intended. It must also be capable of demonstrating what it did, how it behaved, and why those outcomes occurred. The ability to function is no longer the only measure. The ability to account for that function is becoming just as important. This shift does not remain at the level of the application. It extends downward into the infrastructure that supports it. Identity systems, cryptographic controls, and the operational data that records system behavior all begin to take on a more central role. What was previously treated as background detail now carries weight. Operational data is no longer just a technical artifact. In the context of dispute, investigation, or litigation, it becomes a source of record. That introduces a different set of pressures. Questions around ownership, integrity, and verification move into focus, alongside a more fundamental issue. Who has the authority to establish what actually happened within a system? The idea of a passive platform becomes difficult to sustain in that environment. Systems are no longer judged solely on what they enable. They are judged on how they are constructed and whether they can withstand scrutiny. In this episode, we explore that transition and what it means for the infrastructure that underpins digital trust. Not as a theoretical shift, but as something that is already beginning to take shape in legal, technical, and operational terms. Joining me to explore this are Maya Hartman and James Calloway.
Usually when we think about courtroom drama, we picture like a smoking gun, a hidden email where some executive admits they knew a product was dangerous, or maybe a recorded phone call.
Right, something tangible, a piece of evidence that is undeniably visibly human.
Exactly. But if you look at the legal battles that are tearing through the tech industry right now, the smoking gun looks completely different. It's not a leaked memo. It's a string of numbers.
Yeah, it's server logs, the invisible digital plumbing that honestly most of us just assumed was incredibly boring background noise.
Yeah. So, welcome to today's deep dive. Our mission today is to decode this massive, completely invisible shift happening right now in the architecture of the internet. We're looking at a reality where those boring server logs are, well, they're suddenly becoming the most explosive evidence in modern courtrooms.
And to really understand it, we are pulling from a fantastic stack of sources today.
We are. We have a series of highly detailed articles by Steve Atkins. He's the publisher of the Quantum Space, and we're specifically looking at his pieces titled The End of Passive Platforms, When Logs Become Evidence and When the Courtroom Becomes the Compliance Engine.
Great reads.
Yeah. And alongside that, we're analyzing a really revealing interview transcript with Todd Person, the CTO of the data platform Hydrolix.
Which gives us, I think, a perfect lens to view this whole thing through. We get the intense legal analysis from Atkins, right, rounded by the hardcore infrastructure engineering reality from Person.
Right, the theory and the practice. And if you are listening to this on your morning commute or, while you're working, I want to set the stakes for you. Because whether you are just endlessly scrolling on your phone or you are actively building complex enterprise software, the fundamental rules of the internet changed last month.
March 2026.
March 2026 was an absolute watershed moment. Now, a quick caveat before we dive into the mechanics of all this. This topic touches on some incredibly heated political and legal debates regarding social media safety and new legislation.
Yeah, it's a minefield out there right now.
It really is. So I want to be clear. Our goal today isn't to take a side or, litigate the politics of it all. We are looking purely at the facts in the source material, the architectural mechanics of what actually happens when a court steps into the server room.
Because the ground has truly shifted under our feet. And to understand the engineering response, we first have to understand the legal earthquake that forced it.
Which brings us to March 25, 2026. A Los Angeles jury delivered what our sources are calling the most consequential technology ruling of the decade.
The KGM case.
Right, KGM versus Meta Platforms, Inc. and YouTube, LLC. The jury awarded the plaintiff, who is a 20-year-old woman, $6 million, finding both Instagram and YouTube negligent.
And the breakdown of that money is important.
It is. It was a $3 million compensatory award and then a massive $3 million in punitive damages. And that's because the jury explicitly found the companies acted with malice, oppression, or fraud. Liability was split, so Meta took 70% and YouTube took 30%.
And, the human element of this trial was just devastating. KGM testified that she started using YouTube at age 6 and Instagram at age 9.
Which is, that's 4 years below the platform's own stated minimum age requirements.
Exactly. And she described spending her entire childhood on these apps, developing severe depression and body dysmorphia. It got to the point where she was hiding in school bathrooms just to, check the metrics on her posts.
Yeah, and during the closing arguments, her legal team brought in this physical 35-foot-long collage of the heavily filtered selfies she had posted as a child.
Wow.
The visceral impact of that in a physical courtroom, it cannot be overstated. But as I was reading through the source material, I kept hitting a wall on how this even made it to a jury in the first place.
Because of Section 230.
Right. For decades, tech companies have been virtually bulletproof because of Section 230 of the Communications Decency Act. The whole, we just host the content, we aren't liable for what users actually post defense. So how did the plaintiffs bypass that?
Well, what's fascinating here is that this is the legal masterstroke of the entire case. The plaintiff's attorneys knew that if they sued over the content KGM was looking at, like the specific videos or photos, the case would just be immediately dismissed under Section 230.
Yeah, thrown right out.
Exactly. So they explicitly instructed the jury not to consider the content itself. They didn't attack the media. They attacked the machine.
You targeted the system design.
Yes.
Yeah.
They framed features like the infinite scroll, the algorithmic autoplay, personalized push notifications, even the augmented reality beauty filters. They framed all of that as a fundamentally defective product. Yeah, they argued these features were engineered to bypass rational decision-making and foster compulsive use, especially in developing brains. By legally defining the algorithm as a defective product rather than, a publisher of speech, Section 230 simply didn't apply.
Okay, so let me unpack this just to make sure I'm getting the mechanism right. It's like, instead of suing a driver for reckless speeding,
Right.
they successfully sued the car manufacturer for deliberately installing faulty brakes that made the car go faster without the driver's consent.
That is a perfect analogy. Yes.
That is wild, and the timing of this strategy finally landing a massive blow is just incredible. Just a day before this Los Angeles verdict, a Santa Fe jury ordered Meta to pay a $375 million civil penalty for violating consumer protection laws.
Yeah, specifically finding they knowingly concealed risks to children.
Right. And then you layer in Mark Zuckerberg's testimony from February 2026.
His first ever jury testimony, which was highly illuminating, he was questioned about internal documents, including that now infamous memo that stated, if we want to win big with teens, we must bring them in as tweens.
Man.
And the plaintiffs demonstrated that 11-year-olds were 4 times as likely to return to Instagram compared to competitor platforms. The executives kept testifying that safety was a priority, but the jury looked at the internal data and the system's actual performance, and they clearly concluded otherwise.
Right. I mean, Senator Ed Markey called this tech's big tobacco moment. And Steve Atkins points out in his articles that this Los Angeles verdict rests on the exact same 3 pillars that dismantled the tobacco industry back in the 1990s.
Yes. Corporate knowledge of harm, deliberate targeting of a vulnerable population, and sustained public denial.
It completely shatters the whole illusion of the passive platform. Regulators and courts, they are no longer treating these companies as neutral intermediaries that are just, passing data back and forth. They're now viewed as fully accountable systems.
The new legal standard is that if you design a system that actively shapes user behavior and influences outcomes, you own the liability for those outcomes.
So if courts are now forcing platforms to be accountable for exactly who's using their product and how they are using it, that kind of implies the platform actually knows who is sitting on the other side of the screen.
You would think so, yeah.
But looking at Todd Person's data from Hydraulics, the reality of the internet's plumbing tells a very different and honestly terrifying story.
Yeah, we have to talk about the dead internet problem. And just to be clear for everyone, we don't mean the internet is offline or broken. We mean the foundational assumption that a living, breathing human being is generating the traffic on the other side of a connection. That assumption is mathematically collapsing.
Yeah, Person estimates that human-to-machine traffic on the internet is currently sitting at about a 2-to-1 ratio. But he expects parity, where automated bots and AI agents make up a full 50% of all global internet traffic within the next 6 to 12 months.
Which is just staggering. And the speed of that transition is what's catching infrastructure companies completely off guard. It used to be relatively easy to spot automated traffic. A bot would execute the exact same request at the exact same millisecond interval using the exact same browser headers.
Right, it was simple pattern recognition.
Exactly. The line between human and machine was highly legible to security software.
But Todd points out that modern AI agents, they don't behave like simple scripts anymore. They actually simulate human variability. How are they actually doing that to the point of, fooling enterprise security?
An AI agent today can be instructed to introduce microscopic jitters into its simulated mouse movements so it doesn't move in a perfectly straight line like a robot.
Oh, wow.
It can pause its scrolling to mimic human reading speed. It can continuously rotate through residential IP addresses so it looks like a teenager browsing on a suburban home Wi-Fi network rather than, a server farm in another country.
That's terrifying.
The behavioral signals that security teams have relied on for 20 years are now entirely corrupted. They're an unknowable baseline.
Wait, okay. I'm trying to connect the legal mandate with this engineering reality, and it seems impossible.
It's a huge clash.
If AI agents are acting exactly like humans and making up half the traffic, how on earth does a platform legally prove to a judge that an actual 11-year-old child is logging on versus a bot?
That is the core of the crisis right now. Age restriction and identity verification are no longer just interface issues. You can't just put up a pop-up box that asks, are you over 13?
Right.
Self-declaration does not meet the standard the law now demands because a sophisticated bot can click that box just as easily as a tween can.
And if they ask for like a driver's license upload or something, a generative AI can forge one in 3 seconds.
Exactly. So we are facing a profound identity infrastructure issue. Steve Atkins notes that the direction of travel here is moving toward models like the European Digital Identity Wallet. The concept is that trust has to shift from a checked box to a cryptographic, engineered capability.
But how does that actually work for the everyday user?
Yeah.
I mean, I don't want to hand my passport over to every single website I visit just to read an article.
And the beauty of cryptographic trust is that you don't have to. Instead of handing over your raw data, a trusted authority issues you a digital token.
Okay.
When you visit a site, that token simply verifies an attribute. Like it provides a mathematical proof that says, yes, this user is over 18 without ever revealing your name, your address, or your actual birth date.
Ah.
But the system has absolute unforgeable certainty that the condition is met.
So if the front door is broken, if surface level signals and checkboxes mean absolutely nothing against bots, and they mean nothing to a jury, platforms have to look deeper into the plumbing to prove what actually happened. They have to look at what the system physically did.
Yes.
And this is where the concept of observability suddenly becomes the most important term in tech.
Yeah, observability used to be viewed as a pure IT support function, right? You check the server logs to see why a database crashed or why a website is loading slowly. But Todd Person makes a brilliant observation in his interview. Modern security tooling is essentially just highly sophisticated log management.
And the sheer scale of this data is staggering. I mean, he mentions that during massive global events like the Super Bowl or the Olympics, digital infrastructure systems are generating upwards of a petabyte of log data in a single day.
A petabyte a day. That's 1 million gigabytes of pure behavioral text every 24 hours.
It's unbelievable.
But the interesting part is that scale is largely a solved problem. We actually have the databases and the ingest pipelines to handle a petabyte a day. The fatal mistake organizations make isn't a lack of capability, it's a financial choice.
Right, because storing a petabyte of data every single day gets incredibly expensive. So they discard it, they sample it, maybe they keep 1%, and they just throw the rest away.
And by choosing to discard that data, they create their own blind spot. They leave themselves entirely defenseless during a security breach, or, more importantly in 2026, during a legal crisis.
Here's where it gets really interesting to me. It's like we used to treat server logs like a grocery store receipt, right? You glance at it to make sure you weren't overcharged, and then you throw it in the trash as soon as you walk out the door.
Exactly.
But under this new legal framework, a server log is no longer a temporary receipt. It is a permanent, unerasable DVR recording of every single micro-action you ever took inside that store. Which aisle you walked down, how long you stared at the cereal, what you put in your cart, what you put back on the shelf.
That's a great way to look at it. The data doesn't just describe what is happening. It becomes the authoritative record of what did happen. And the big tobacco parallel strikes again here. The evidence of wrongdoing, the proof of what a company's algorithm actually did to a user, isn't coming from an external whistleblower smuggling out a manila envelope.
Yeah.
It is continuously being generated by the system's own architecture. The shift in perspective is subtle, but it is massive. The question for tech executives is no longer simply what is happening inside our system.
It's can we prove it?
Exactly. Can we cryptographically prove what happened in a court of law? The logs are transitioning into a high-fidelity, permanent ledger of behavioral evidence.
And because those logs are now permanent behavioral evidence, the legal dragnet is expanding rapidly. It's not just the social media giants getting sued anymore. The companies that merely monitor or deliver that traffic are suddenly finding themselves dragged onto the witness stand.
Yeah, and this is perhaps the biggest blind spot for the broader tech industry right now. We're talking about infrastructure providers, content delivery networks, or CDNs like Cloudflare and Akamai, observability platforms like Hydraulics.
But hold on, I'm struggling to see how a CDN gets dragged into this. If I'm an infrastructure company, I'm just the digital plumbing, right? I'm just the pipes moving the water. Why should I be legally on the hook for what a social media company's algorithm does to a teenager?
Well, if we connect this to the bigger picture, infrastructure is not neutral. CDNs do not just passively pass data along a wire. To make the internet fast, CDNs cache content at the edge of the network, physically closer to the user. They tune delivery, they optimize performance, they reduce latency. In doing so, they actively influence how content is consumed.
Oh, I see. Because they are optimizing for speed, they are effectively optimizing for engagement.
Precisely. And because observability platforms retain the resulting log data of that optimized delivery, they hold the exact session-level granular data that proves whether a platform's addictive design claims are true or false.
Right, the actual receipts.
Think about it. If a social media company testifies that teenagers aren't doom scrolling on their app, but a CDN server logs show millions of underage sessions lasting 4 uninterrupted hours with high-frequency API calls requesting more content, well, That log is the smoking gun.
Wow.
Infrastructure companies don't need to control the system to become accountable. They just hold the unalterable records that explain how the system behaved.
And we are already seeing legal precedents setting the stage for this dragnet. In November 2025, the Tokyo District Court ruled against Cloudflare for aiding copyright infringement by piracy websites.
Yes.
And the court didn't attack Cloudflare's underlying technology, right? They targeted their lack of know your customer procedures. They essentially said, you can't claim ignorance about who is using your massive infrastructure.
And we saw an even more aggressive move in January 2026. A federal court in the Southern District of New York ordered OpenAI to produce 20 million de-identified ChatGPT logs for a lawsuit brought by news publishers regarding copyright training data.
20 million logs.
Yeah, the court placed operational server logs on the exact same legal footing as any other vital enterprise software record. Operational privacy just does not shield you from discovery anymore.
Which brings us to the framework Steve Adkins introduces in his articles to make sense of all this chaos.
Yeah.
The TQS Trust Stack. It's a 5-pillar framework, but what's really terrifying is that it's no longer just a theoretical best practice model. It is becoming legally enforced.
Yeah, let's trace a user's action through this stack to see how it works in reality, because it maps exactly where legal accountability attaches to the engineering. It starts with the first pillar, identity,
which determines who is participating. And as we established, self-declaration is dead. This is where the cryptographic verification of an attribute, like an age check, has to happen before the interaction even begins.
Right. Once identity is established, we move to the second pillar, system logic. This is how the interaction is mathematically structured. This is the algorithm determining what content you actually see.
And this is exactly what the Los Angeles jury just penalized. The system logic, using what psychologists call variable ratio rewards, the slot machine effect of not knowing what you'll see next when you swipe down to enforce compulsive behavior.
Exactly. Moving down the stack, the third pillar is cryptography. Once the user interacts with that system logic, the system needs the ability to verify without a doubt that a specific behavior happened at a specific time and that the record hasn't been tampered with.
Which feeds directly into the fourth pillar, which is security. This is where the permanent ledger lives. This is the domain of the observability platforms like Hydraulics, managing the petabytes of cryptographically secured logs, providing total auditability of the event.
And wrapping around all of this is the fifth pillar, policy. These are the operational and legal boundaries, like the Digital Services Act in Europe or the new consumer protection laws in the US.
Looking at it as a stack, you really realize how interconnected the liability is. You can't enforce a policy without knowing the user's identity.
No.
And you can't prove that identity or defend your system logic in court without the cryptographic logs generated by your security layer.
It is an entirely unified architecture of accountability. Everything relies on everything else.
So what does this all mean for you, whether you're a casual user, a developer, or a tech founder? Well, the era of move fast and break things on a passive, consequence-free internet is officially dead. The systems that shape our digital behavior are now fully accountable. And the evidence of that accountability isn't waiting in an executive's outbox. It is being written right now into petabytes of log data every single day.
It's a total paradigm shift. And analyzing these sources leaves us with a critical and perhaps unsettling final thought to mull over.
Yeah.
If the only way to avoid multi-million-dollar design negligence lawsuits is to mathematically prove the exact age and identity of every single user interacting with a platform through an engineered trust stack, does this mean we are quietly witnessing the absolute end of online anonymity for the everyday person?
Wow, that is a massive question to leave off on. We started this deep dive talking about server logs as the new smoking gun, and we leave realizing those logs might just be tracking and verifying every digital move we make. Thank you so much for joining us as we unpack this source material. Keep questioning the digital world around you, and we'll see you next time.
What emerges from this discussion is not a distant shift or a theoretical direction of travel. It is already beginning to take shape in how systems are examined, how responsibility is assigned, and how decisions are challenged. The idea that infrastructure could remain invisible while carrying increasing levels of responsibility was always going to come under pressure. What we are now seeing is that pressure being applied in a very direct way. As systems become more complex and more autonomous in how they operate, The expectation that they can account for their behavior becomes harder to avoid. That expectation does not sit at the surface. It moves down into the layers that record, verify, and ultimately define what happened. That has implications not just for platforms, but for the entire trust stack that supports them. The ability to demonstrate system behavior, to establish integrity of data, and to provide a verifiable account of events is starting to look less like an operational requirement and more like a structural one. It shapes how systems are designed, how they are governed, and how they will be judged when something goes wrong. What becomes clear is that the question is shifting. It is no longer simply about whether systems can be trusted to operate. It is about whether they can be trusted to explain themselves under scrutiny. And in an environment where that scrutiny increasingly comes from courts, regulators, and counterparties, the ability to provide that explanation may well define who holds control. You've been listening to The Quantum Space, Innovating Trust. You can find more analysis, articles, and related discussions at thequantumspace.org.
This was The Quantum Space, Innovating Trust, produced and edited by Crown Communications.